Hi, this is Reverend Dr. Nadine Rosechild-Sullivan reading to you from my book, Passing the Baton, Birth Control, Precondition of the Liberation of Women. I want to give a trigger warning tonight. There will be rape discussed in this chapter, and paternal rights in regard to rape, and also the telling of a narrative, which involves a description at some level. I am beginning on page 48, and this section is called Paternal Rights in the Family Court System. Whatever your sex or gender or sexual affectional orientation, whomever you procreate with is remarkably important, and your procreation should, as much as possible, be chosen and thoughtfully chosen. The partner or partners you procreate with will dramatically affect your life and the lives of any and all children you have. Whomever you procreate with has rights, generally joint rights throughout the 18 years of minority or childhood. A father, more easily than a mother, can, if he chooses, walk away. Biologically speaking, it is impossible for the pregnant woman who chooses to carry or who has no access to pregnancy prevention or abortion to walk away from her own body. A father can, if he chooses, stay, whether for good or for ill. A father who has not been involved, whether through the pregnancy or through the years of early child rearing or even through an entire childhood, can show back up and have as many rights as if he'd never walked away. And while it is possible, it is both difficult and costly to prove a parent, any parent, unfit. In a separation or divorce, many fathers are sincerely interested in responsibly co-parenting their children, and at least in front of the children, honor the woman or women with whom they've had children. But in our present-day culture, heir to approximately 6,000 years of patriarchy, other fathers use children as trophies in a power game, a gendered tug-of-war. And while mothers can also be the villains in this game of alienation of affection, statistically, the balance of power in this contest is not equal. In part, because of the experience to carrying to term, the people with the plumbing to conceive and gestate often end up with a more protective bond toward their child or children. They are also faced with higher social expectations that they will indeed bond with their children, that they will be there, parenting, protecting, and providing for the long haul. So in a discussion of conception and contraception, it is important to touch on the times in which the maternal part of the potentially procreating pair should consider the character of the paternal part of the potentially procreating pair before deciding whether or not to gestate or carry an unintentionally fertilized ovum to or near term. In other words, when impregnated, a woman should think about the man's character before she chooses to carry his seed, because from that time forward, his character will affect her and any child she bears via his sperm as much as anything ever can. Ideally, every child should be wanted, even planned, and have one or more emotionally mature and loving parents or guardians who each take real responsibility, sharing the work and finances of childcare and actively co-parenting throughout the years of minority. All children should have parents who do not injure or neglect, and parents who do not use their offspring as emotional footballs in adult power struggles and games of control and abuse. We have a cultural rhetoric that claims that the court system has the best interest of the child at heart. Yet, when a child is born, no matter who does the caregiving and providing, and no matter how they treat each other or the child, both parents are considered by the courts to have rights to the child. Even today, a child is property. This view of parental rights equivalates to a view in which the child, to the court, is parental property. And culturally, we are only recently emerged from a long history of children being viewed as the exclusive property of the father. And parents who are insecure and controlling can and do use those rights as a fulcrum to assert power over and dominate the other parent and the child as they come and go from the child's life. Generally, the courts are not actually foregrounding the best interest of the child. Instead, their focus is to establish equivalencies for each parent so that no matter what evidence is presented, custodial conflicts are not generally considered to be grounded in actual paternal or maternal wrongdoing, such as neglect or abuse. Rather, parental custody disputes are minimized and dismissed as mere feuding. Parents of any sex, gender, or orientation can be wonderful, and parents of any sex, gender, or orientation can be neglectful or abusive. And despite the intensity of the bond that can develop between mother and child through the long process of gestation, birthing, nursing, and nurturing, men are capable, if they will, of being as good parents of nurturing as women are expected to be. Men can bond. Nevertheless, in our culture, mothers still make up the majority of childhood caregivers, especially during infancy and the toddler preschool years. And nevertheless, in our culture, because we socialize males into an ubiquitous, hegemonic model of hyperviolent masculinity and into the dominance over and the subordination of women and children, statistically, males make up the overwhelming percentage of physically violent and/or sexually abusive partners and parents. Women can be there too, but we socialize women and men differently, and this creates this disparity. The rates of child abuse are simply epidemic in our society. For the last few decades, and only for the last few decades, there have been laws on the books against child abuse, mostly since the 60s and 70s when survivors began to step forward. But courts still frequently back the rights of fathers, even when they have been demonstrated to be physically and/or sexually abusive to their children. Even when there is sufficient evidence, the courts are suspicious of claims by one, generally the female parent, that the other, generally the male parent, is an abuser, viewing these claims as mere hype or rhetoric in the separation divorce conflict between warring former lovers, disbelieving the generally female accuser. Along with ignoring or dismissing evidence, this perspective fails to take into consideration the proven emotional, psychological harm to the children of witnessing abuse to or between parents. The courts make little to no effort to protect children from living with adult-on-adult physical, emotional, verbal, or sexual violence. Even when there has been a long history of domestic violence calls by the mother to the police, the demonstrated fact that a father has physically abused the mother of his children or stepchildren is considered to have no bearing on his relationship with those children, except when there is an actual criminal conviction for domestic violence, and even then, he is likely to be entitled to unsupervised visitation with the children and may go through a process to gain back his full custodial rights. Further, even when a father has been demonstrated to have physically abused, not just his adult partner, but also his child or children, the courts, working from the idea that children are property to be divided between contesting parties, also holds the idea that children need interaction with, rather than protection from, abusive fathers and sometimes mothers. Therefore, the courts routinely seek to reinstate the custody and visitation of proven abusers, with only a minimal show of obedience to mandated counseling sessions or anger management classes. As already demonstrated in the footnotes for this chapter, this may remain true even when the parent is a sexual offender and has offended against his own and/or his partner's other children. Now I'm going to read a narrative and then a little more text. This narrative, again, trigger warning, this narrative speaks about impregnation by rape. So on page 56, it's called Witness for the State. He was exactly the rapist we are taught to fear. While most rapes are committed by perpetrators we know and often trust, this was the actual stranger rapist, the one who shows up only 22% of the time, the guy with the knife or the gun, and the element of the dark and of surprise. I was walking home from the bar. That didn't help my case, the beer-bellied, mustachioed cop muttered as he took down the facts. Never mind that I was wearing sweats and a giant overcoat, and that my hair was pulled back in a ponytail at the nape of my neck and covered in a baseball cap, and that I was makeupless. I had stopped on my way home from babysitting at my mother's for an 11 p.m. beer at a local pub, and I was young and thin, and at least in the old fat cop's estimation, not ugly. And when uncovered, my hair was bleach blonde. In his police report, I was a loose woman on the street at midnight having consumed some alcohol. Perhaps the assailant had mistaken me for a streetwalker since I was walking the street at night. Perhaps he had thought that I was for sale, even though his only payment was the knife blade against my neck. Perhaps he had seen me without the overcoat in the pub and followed me out thinking I was asking for it. Some guys are like that, the cop said. They think with the way you look that you want them. Then they get punished for misreading your intentions. The physician between my legs finished combing my pubic hair for the assailant's pubic hairs and secured his combings next to the fluids he had already collected from my vagina, while the male cops stood too far south of the medical sheet covering my thighs where they could, between their jottings on the police form, sneak a furtive look or a prolonged ogle at my exposed vulva. The female nurse seemed oblivious to all the men around my lower half, and I closed my eyes to blot them out. Then I was pretty much stripped the rest of the way as the police photographer posed me angle by angle to document all of my wounds and bruises. And the physician, stitching the places I'd been merely sliced, noted, "You were lucky, young lady," pointing out the proximity of some of my wounds to vital organs. Lucky. Despite the unfavorable police report, the DA decided to prosecute. There had been a series of incidents in that section of Fort Wayne, and the DNA matched some of the other recent raid kits, and he thought with my testimony, he had a case. Later that week, they brought me in for the lineup. It didn't matter that I wanted nothing to do with it. My roommates had taken me to the hospital. I hadn't wanted to go, but they had insisted when I wouldn't stop bleeding, and thus the whole second nightmare had begun. From behind, and then in the dark on top of me, I had not gotten a full look at my assailant, but the one I picked out of the lineup, based more on the tenor of his voice than his visage, turned out to match the DNA from the pubic hair and sperm. And since he matched for the other women too, we were all informed we would be subpoenaed to testify. We must show up or they would arrest us for contempt of court. We were not plaintiffs, but witnesses for the state. The days crawled by, inching their way toward the court date. I slept as much of the time as I could, pulling the blanket over my eyes at each encroaching sunrise. Each awakening brought it back, along with a new round of nausea and the desire to sink back into the blessed unawareness of sleep. Unawareness except for when I was startled awake from the nightmare of the knife blade pressed against my neck, or of the delight in his voice as he etched its steel tip into my flesh or plunged it near one of those vital organs, or of the slurping sounds he made as he climaxed his dirt into my vagina-turned gaping wound. It took a good month before it dawned on me that I hadn't seen my period. Maybe a month and a half to question the source of my nausea, which by now filled my mouth at every thought of food. My worst fears were confirmed. My roommates thought it might be best if I went home to my mom. I hadn't worked since the incident or contributed to the rent. They couldn't afford to spot me month after month and needed to get another roommate to fill my place. It was hard to rent my room with me passed out in the bed or retching over the side of it into a trash can. I was, after all, stinking up the place. We discussed abortion. They said between them, they could come up with maybe 100. Would my mom make up the rest? They poured me into one roommate's car, the one owned by the only one of us with a real job, and poured me back out into my mother's house, most of my belongings folded neatly into one oversized laundry basket. As I crawled into her bed, they told her my condition. My mother was adamant. Her answer was no. Absolutely no. I was already 7, maybe 8 weeks along, and she was a Christian. Her church had opened a ministry to young mothers. They would help with a crib, a stroller, some newborn clothes, and earth-friendly cloth diapers, and a set of sterilizable baby bottles. I could live with her. And while helping her with her babysitting service, I could care for my own. She put her foot down. There would be no abortion for me, not in her house, not with any of her money. I couldn't think. I pressed myself into her extra room, made a mat on the floor behind her sewing machine, and slept away another month. By the time the court date came, I was big as a house. My mother couldn't figure out why I was showing so much so early, but she found an old maternity top at a local thrift, repaired it on her machine, and dressed me for court. The trial was a blur. His presence in the room kept me dissociated. There was a judge. There were lawyers. There were his other known victims with similar stories. Questions flew at me. I repeated the facts that had burned into my brain on continuous nightmare repeat across the long months. His was the voice, the fear, the knife blade that glinted in my sleep paralysis. His, the low, threatening timbre, do what I say, or tonight you die. In retrospect, it wasn't possible. Still, it never even occurred to me to try to hide my belly from him or from the court. When they let me leave the stand, I left the courthouse. My mother told me later they convicted him. I had no prenatal care. 19 years old, sleeping on my mother's floor. There was no insurance, so no prenatal care, and no trauma-sensitive treatment for my mind or heart. My mother rearranged her sewing room and got me a used twin mattress on a steel frame. It was the best she could do. The church, she assured me, would get us a crib soon. My pregnant belly and back were grateful for the real mattress. When my labor started, my mother drove me to the ER, where they admitted me to maternity. She held my hand as the pain washed over me in waves. The doctor was concerned. I was a month early. He thought he heard 2 heartbeats. After hours of no progress contractions, the fetal monitor showed the twins' distress. So they wheeled me from my labor room to the obstetrical OR and lifted them out about a minute apart. My mother beamed. She said, God gave you 2 to make up for your trauma. I liked kids, but to me, they looked like him. They felt like his dirt, birthed from my wounds. I tried to shake the feeling, and little by little, I warmed to their tiny, bird-like, open-mouthed rooting and their helpless dependence on me for every moment's needs. My mom's church did help, even with formula, though they were too cheap to spring for Pampers. I have to say, scrubbing newborn poop off of cloth diapers ×2 was really difficult on my still touchy stomach. They were not yet 6 months old when his lawyer's letter arrived. The assailant, who had received only 8 years for the rapes and non-fatal stabbings of 3 strangers, was demanding a test to establish his paternity and a judicial hearing to establish his custodial rights. I was to bring the children to the designated location for medical examination. They were, of course, his. Paternity established from prison, a judge awarded him visitation. I was to update him by letter and send pictures of his children's progress over the next 6 months. And beginning with their first birthday, I was to bring them to prison bi-weekly for supervised visitation with their father until his release, either at the end of his sentence or earlier if he earned time off for good behavior. If after release he convinced the court of his suitability, the court would establish his paternal rights to joint legal and joint medical custody and to unsupervised weekend visitations, holidays, and vacation schedules, and to full residential custody where I to predecease him during his children's minority. By court order, the criminally ill monster who had stolen my and at least 2 other women's sense of self and safety, and of cleanliness and ability to sleep through the night, or to simply walk to a car after dusk, had the right to be trusted to provide both my daughter and my son with their male parental role model with no concern for just what he would model for life. In the eyes of the court, they were equally his. In the eyes of the court, this was in their best interest. Now I will end with a few more pages, just 3.5, of a section called Abortion in Rape, beginning on page 62. Parental property rights and their impact on the failure of the courts to truly operate with wisdom in the best interest of children bring us back to the sole exception sometimes allowed by the anti-choice movement: early term abortions on the grounds of rape or incest. Overwhelmingly, when a pregnancy is the result of rape, the rapist is viewed by the family court system as having rights to his offspring. And there's footnotes throughout these sections. He is viewed as having rights to visitation, supervised or unsupervised, and or rights to joint custody, joint legal, joint medical, or joint residential, or even rights to sole custody of the children created by his acts of sexual assault. And his victim, the children's mother, or the child's mother, may be commanded to transport her child or children even to prison to visit him, forcing her to see her assailant again regularly, or to turn her children over to her rapist for and pick them up from him after his custodial time. And this, even for convicted rapists, the overwhelming majority of whom are stranger rapists, because they don't really convict acquaintance rapists that often. And this even for stranger rapists convicted of the rape that caused the impregnation. Most convicted rapists are stranger rapists, 22% of rapists, as acquaintance rapists overwhelmingly do not go to prison. Most acquaintance rapists, 78% of rapists, also do not even go to trial, as most acquaintance rape cases are difficult to prove in court and are therefore declared unfounded, which is not the legal equivalent of untrue, but rather indicates that the district attorney cannot predict with certainty that under the rules of the current system, the case can be won, and therefore opts out of prosecuting. In our system, sexual assault victims do not press charges against perpetrators. It is the state, the police, and then the district attorney who make that judgment call, reducing the victim when the DA does decide to prosecute to a mere witness for the state. And rape is a crime of opportunity that generally happens without witnesses, which from a legal perspective means that most cases don't meet the threshold of evidence necessary for a DA, a lawyer who needs a record of career wins, to decide to take them to court. Instead, assaults committed in the dark and without witnesses by persons the victim knows are dismissed as mere he said, she said disputes about intent. Overwhelmingly, the assailants the DA chooses to prosecute are the strangers who lay in wait in the bushes, wielding a weapon, leaving bruises, wounds, and scars. Therefore, it is not surprising that in the United States, an estimated 90% of rapes go unpunished in our legal system. So if you are raped in the United States, understand it is highly unlikely that your assailant will be prosecuted. And understand that even if your rapist is prosecuted, convicted, and sentenced, if you are impregnated by that rape in our family court system, if your rapist pursues them on DNA test, his paternal rights can be upheld and enforced. Even when the physical violence against his victim is severe, it is highly unlikely the rapist's paternal rights will be severed. So if you are impregnated by rape and choose or are forced to carry to term, know and understand that your assailant, whether prosecuted or unprosecuted, and even if prosecuted and convicted, will be able at any time to demand his intact paternal parental rights, even from behind bars. He will have the option across your children's or child's minority to establish and exercise his father's right to parental visitation and or custody, and as the father would be the first guardian of choice, despite whomever you may designate in the event of your untimely death. In all likelihood, you will not be able to prove him a rapist. And even if you can, even if he were the violent stranger in the bushes with the knife who wounded you sufficiently for the DA to choose to prosecute, he will still be able, from prison, to petition the court to have you bring his children to him for visitation, thus exposing your young child or children to the prison environment and to the self-concept of being the child or children of a convicted rapist. And upon his release, to seek unsupervised time with them alone or joint or sole custody. You could be forced to see him over and over across your lifespan, and you can be forced to give him access to the child or children he helped create via rape. In that event, he will, one, function both as your son's and or daughter's role model of masculinity and fatherhood, and he, a rapist, two, will have sexual access to them according to his desires across their entire childhoods and adolescence, across their minority. The courts are unlikely to protect you or them. In regard to visitation and or custody, as with demonstrated abusers, there is simply no discussion in the public or in the criminal justice sphere about the ethics or the kind of gender role ideology that a man who impregnates a girl or woman by rape will likely pass on to either a daughter or a son. Or of whether or not someone who already impregnated a woman by rape might be more likely than another parent to rape the child thus created. Recently, some, but not all states have passed rape survivor child custody acts that will allow women in those states who have the financial resources and for whom the state has been successful at proving their charge of rape in court, a minute fraction of rape victims, to petition the court for the loss of the rapist's parental rights. Let me say that again. Some states, but not all, have passed acts that will allow a woman with the money to go to court and to seek to have the parental rights of a convicted rapist severed. But as she petitions the court for his loss of parental rights, it is only for the child created by the rape. So in the case of an ex who has been violent enough to be convicted, it would not, in the case of an ex, be to any other children he may have created with her. So when the circumstance where a woman has left a man and had children with him, and he pursues her and violently rapes her and is convicted and found guilty, and she petitions and she gets pregnant and she carries to term and she petitions the court to have his rights to that child created by rape severed, she cannot petition the court for his rights to their other children to be severed. Given the level of proof necessary to secure conviction and the reflection on character that committing rape is, I question why, upon conviction of rape, a rapist's paternal rights to the offspring of that rape and to any other children he may have are not automatically severed by the state without the necessity of petition from the victim. How the state can ever view a convicted rapist as a fit parent is incomprehensible. Therefore, even this new measure is only of value in the protection of a very limited number of children born of a stranger rape of which the perpetrator has actually been convicted and in which the mother has the legal, financial, and emotional resources to take her assailant to court to block his custody. The overwhelming majority of children conceived by rape and of women impregnated by rape who choose to carry to viability will not be benefited by these acts. Helping women who choose to carry to term to protect their children from the influence, role modeling, and potential sexual predation of their rapist children's progenitor will require an entire paradigm shift in our criminal justice system and in our cultural rape myths. Right now, societally, we cannot even see the rights of women to be protected from their assailant or the rights of the children of rape to grow up without the unhealthy, potentially highly destructive influence of their rapist progenitor. Instead, the courts see women victims as exaggerants and fathers as having rights of access to their seed. Given the height of the bar for legal conviction, if anything should invalidate a man for fatherhood, it should be being convicted of rape or of being a sex offender against children, even his own.